joining us today. My name is Guillard Sazhko. I'm an associate at Shearman Sterling Paris office. I'm also a member of the organizing committee of the Eastern European Dispute Resolution Forum. This is one of the interviews in a series of interviews organized by the Eastern European Dispute Resolution Forum with the leading legal practitioners. Today, I have an honor to interview Carri Ginter. Carri is the head of the Dispute Resolution and Risk Management Practice in Sorainen law firm in the Baltics and Belarus. Carri is also Jean Chair of the School of Law and Associate Professor of EU Law at the University of Tartu. Carri is an expert on EU law. Therefore, during this conversation, we will look on dispute resolution from a EU angle, touching upon ECJ's competence and some recent developments in the dispute resolution market.
Hello, Anna. It's good to see you, and thank you all for listening. I'm Carri. I'm from Estonia, and I'm really happy to be with you.
Thank you, Carri. Let's start from the basics. When we say dispute resolution in the European Union, what particularities should we bear in mind?
Well, if you talk about the European Union, then it's the most important difference is that your dispute may actually look very much the same on the surface, but when you look into it, a part of it can be European Union law and a part of it can be national law. So may end up with a situation where one legal relationship is actually two at the same time. A part of the relationship goes to the European Union law, which means the national court talking to the European Court of Justice in Luxembourg, and the other part of the very same dispute may be under national constitutional law going to the Supreme Court of your own, highest Supreme Court or your constitutional court. So the importance of noticing the EU law element, that is the most crucial when you're dealing with these issues.
Can you identify cases when a national court should refer to the European Court of Justice?
For us, for example, we have this situation currently at hand when the government of Estonia, the parliament has imposed on the bus carriers an obligation to carry certain passengers free of charge, and it's not compensating them for this. Another example that we have currently is a health check on a fish production facility, where there is a discussion about what health levels a certain activity should meet or not, and whether the standards that apply in the factory are the same that apply in the store or supermarket or in your own refrigerator. So you might end up with a quite normal, regular business day, and a passenger comes on board of the bus and says, I have a right to free travel. And at the same time, it may be that this is a constitutional law issue. Should I get money from the government because my seat in the bus is being confiscated, so to say? Or is it a EU law issue where I should not be overcompensated because of state aid risks? So noticing this element is quite complex.
Now, would you agree that the system might break down if every case is sent to Luxembourg?
This is a good question. I was just meeting my law students this morning for 3 hours and yesterday for 3 hours. And then we looked at some very specific cases. For example, the case of the Tallinn sales tax, when during the last economic recession, Tallinn instituted a new sales tax of 1% of every transaction with private people in Tallinn. And what we saw that there was a risk of this tax not being in conformity with the European Union excise tax rules. And what we saw is that the national court took a year or less than a year to make a decision on first instance. And then it was appealed. And then we see almost 3 years in the second instance in national courts. And the second instance court finally sent the questions to Luxembourg. It took less than 2 years for Luxembourg to respond and say that we were right. And there is no sales tax for Tallinn anymore. It was annulled. So we spent almost 4 years in national judiciary, less than 2 in Luxembourg, and we got a quick result. So if you look at this from the student's perspective or from the practicing lawyer's perspective, if you can get the question out there quickly enough, then after 1.5 or less than 2 years, you will have a key answer on the central problem, and then the rest is just sort of rendering the final award, and there is much less discussion and much less submissions from the parties to the judge. So the judge will have an understanding what the directive says, what is the meaning of this specific purpose of the tax, and then it will be much easier for the judge to decide, and it will be much less likely that the Court of Appeals or Supreme Court will annul it for some reason. So yes, it takes time, but at the same time, looking at the whole duration of litigation, it's not so much. I mean, just 2 days ago, I was in court in first instance on a civil matter where we have been there for almost 3 years, and it's just the first instance. Some say that maybe it's a luck for lawyers to have a case that drags for 3 years in first instance. I would say that it's not the best of luck, and we would rather get new cases and new business.
So how would you address this from a time frame perspective? Would you agree that such referrals prolong the proceedings?
Like I said, the whole process is built on the idea that there is common European Union law. So there is something like the internal market is working. So the same word of European law should have the same meaning in all member states. So a Spanish judge should understand it the same as a Polish or Estonian one. And the sooner you have the national judge approach the Luxembourg court and ask for this single meaning or understanding or the scope of the directive, for example, then you wait for less than 2 years and you have the meaning and you have the understanding and you have the clarity. So it might be actually that it's speeding up the process instead of slowing it down. But it is, of course, counterintuitive because it seems that we are smart enough, we know European law, we are well educated, we have PhDs and so on. But one thing is to have a PhD and one thing is to understand it. But the other thing is that would a judge in Portugal or Spain understand this legal concept the same way as it would in Lithuania or Tallinn? So that's the issue. So I would say that it does not slow it down in most cases. In most cases, you can actually get a relatively quick process in Luxembourg. Of course, this has been affected by COVID, and the court in Luxembourg is also prolonging its deadlines. But if you look throughout history, they have been faster and faster from year to year. So 24 months was the standard. It was 18, sometimes 17 and a half months. So it's quite quick if you think about the duration of litigation. So if you go to court in Spain, I was sued in Spain, for example, for some issues with a swimming pool in Estonia. But anyway, I'm being sued in Spain. So we are there in court now for the second year. And we just had the first hearing. So my lawyer, excellent lawyer from Belarus, I believe she's originally, so now she's representing me in Spain. And it's still 2 years and we still have just the first hearing on a simple libel case.
What are the consequences for not applying to the ECJ for a preliminary ruling?
But to answer your question, if you look at the practice of the courts, then basically there is the Köbler judgment from the European Court of Justice, and there are some other judgments that actually make it pretty clear that if the highest court of the judiciary does not ask for a preliminary ruling, that it may be actually a ground for state liability. So you can sue your own state in your own first instance administrative court and claim damages caused by the highest court of your own country. And the argument will be, if they would have asked for a preliminary ruling in Luxembourg, I would have won the case, and because they did not do so, therefore I have suffered damage and it should be compensated by your own state. That's pretty radical. There are also cases from the Court of Human Rights in Strasbourg, which say that not requesting this preliminary ruling by the last instance court is actually a breach of Article 6 of the Convention of Human Rights. So it's actually an allegation of breach of due process by the highest courts of your own country. And there are some third, results, renewal of administrative procedure and so on, which may also come on the table. So there are a lot of things that can go wrong if properly dealt with.
Is there any other way to address a failure to refer to the ECJ
I am not certain that I'm answering your question to the point. But for example, if you have a customs case in Estonia, for example, or Latvia or Lithuania, and then you fight until the highest court of your own country and you lose. And it's a EU law matter because customs is something that EU has unified. So there's like a common customs union. And if you now lose and the court makes a wrong decision, and then later, maybe even 5 years later, someone else in another country fights the same issue and ends up in Luxembourg. And the court in Luxembourg says that they were right, which in turn means that you were right 5-6 years ago. Then actually under the practice of the Court of Justice, you can go to your own national authorities and apply for renewal of administrative process. So they are under an obligation to renew the administrative process on your ages-old case and look at it once again. And that may create a lot of risks on res judicata and the finality of judgment in general. But that is the risk that the national judiciary will take if they do not approach the court in Luxembourg.
Thanks, Carri. Now let's move to another interesting topic. 1st January 2021 was not only the beginning of a new year, it was the beginning of a whole new era in the UK-EU dealings. I know that you are in a reserve list of candidates who are willing and able to serve as union members of an arbitration panel under the withdrawal agreement. What does it mean?
The departure of the United Kingdom has been quite painful for both sides. And obviously, because of this departure, the UK and EU are no longer in the internal market relationship under the same treaties that they were before. And for this situation, obviously, the Brits will have some doubts as to the impartiality of the EU judges in Luxembourg to rule over their disputes with the European Union. And therefore, we are resulting in an arbitration agreement between UK and the EU, and there has been a list of people set up who are willing and able to serve if such disputes would actually arise. And as a result, then, once these disputes arise, we will be able to possibly help to increase prosperity in both the EU and United Kingdom.
Now let's move to my favorite part of the interview, 10 quick questions. My first question is, why did you decide to become an associate professor?
It's a very simple answer. I started learning European Union law in '96 in law faculty, and Estonia didn't join EU until 2004. So when I graduated from Stockholm in Masters of EU Law in 2001, there was really two options for me. One is forget EU law or somehow find a way to keep it. And then I went to the faculty, and that's how I have kept my competence in EU law ever since.
What is the most challenging part in teaching students nowadays?
Currently, the most difficult part is actually being able to develop your own skills online. Because you can easily go in front of the students and have like a black box. So you are talking into a box and you don't know what is happening on the other side.
Do you work on any project aiming to guide young generation of lawyers?
We have a really interesting project from the European Commission in Erasmus Plus, which is called the Jean Monnet Chair. And it was given to the Tartu University upon our application. And instead of applying with a long list of PhDs and celebrity professors, we chose to apply with young talent, meaning fresh graduates and possibly some students still. And our project is called Engaging Young Talent in Promoting Comprehensive Understanding of European Union Law, so U-Pro-U.
What was the most original business destination for you?
It is a good question, and I must say there is a traditional answer that I do love going to London, or I do love going to London still because of It's just such a vivid city, but maybe most interesting for me, still I was shocked and positively surprised when I first visited Minsk. I do love Minsk and Belarus in general. It's a beautiful, beautiful city. And I was stunned because, I mean, we also have our roots in the Soviet Union, and I was expecting something much, much less impressive. And when I landed in Minsk, and I've been there many, many times after that, I do love every time visiting it. And it's a beautiful city. It's very hospitable, and we have business interests there. So it's, yes, Minsk is definitely one of these destinations. Then you can go on with Copenhagen and Vienna, but they are all very traditional, Stockholm and so on.
You speak 5 languages: Estonian, English, French, German, and Russian. What is the most efficient method in learning a language?
There is an honest answer. And for me, the honest answer is that it is extremely difficult. It was extremely difficult for me to learn French or German, for example, in school. Because the way the subjects were taught and the way they were structured, it was very, very difficult. But because of my fondness of TV, I have learned a lot of German by watching really ridiculous shows on ProSieben and RTL and Knight Rider and A-Team and all of that. And if you're a 14 or 15, then you very easily learn what you need to know about what this guy is saying, who's shooting the other guy. And so TV is definitely a way to learn a foreign language and then support it with the studies. And the same is with music. So watching films and listening to music, it's hugely helpful, and then combine it with the studies.
What is the most challenging part in being a legal expert?
The correct answer is, of course, obvious, that staying an expert is something that is very challenging because you have to run really, really fast in order to stay in the same place. To be an expert is an everyday job. And then when you're practicing as a litigator or dispute resolution lawyer, then you are constantly on the battlefield. So your days look like, I've tried to describe it to someone who's not a lawyer by profession. I said, my day looks like a computer game with different monsters flying towards me, and I have to be as quickly as possible able to shoot them with a gun. And then when you finish the day and say, should I read the next European Law Review? Then you think, no, I will watch a movie. And
what does it take to succeed as an arbitrator?
First of all, to succeed as an arbitrator, you have to gain the trust of the market. So people have to trust you that you're an honest, hardworking person. And that is the most challenging part of it, because to have someone actually recognize you and think, okay, this person can be trusted not to be corrupt or not to be lazy or actually can speak English, for example, that is a high challenge. And then the second challenge is really this responsibility and persistence, so that if you get this pile of information and then you do take the time to read through it, and you do take the time to look at the exhibits, and then that you are able to cooperate with the panel.
What makes a brilliant lawyer?
It is a very difficult question to answer, what makes a brilliant lawyer, because there are very different brilliant lawyers. And I remember this partner of a big law firm who said that they have brilliant tax lawyers who don't like to meet other people or come out of the room. They just want to be given food and paperwork from under their door. So give me taxes, food, but please don't talk to me. And that could be a very brilliant lawyer. It can be an excellent career. And don't get me wrong, not all tax lawyers are like that. Many tax lawyers are also very outgoing and friendly. But like I said, there is this element of curiosity, persistence. First of all, that you don't give up, you keep going. Things get tougher, you keep going, you don't give up, you don't panic, you sort of, discomfort is a normal situation for you. You are not surprised or astonished, because as a litigator, for example, it's not easy to surprise you, because you have seen many things coming and you will just look at it and say, okay, this is also a way to approach it. And then this curiosity and to dig into material, to try to find the right solution. Why is this on the table? Why is this happening? How can it be interpreted? Where are the sources? You just go very, very, very persistently into it. And then the third element is then curiosity towards people. So why is this person behaving the way it is? If I do this, how will they react? Is it necessary for me to take their dignity in order to achieve my victory? Normally, it's not. You don't need someone's dignity in order to win. And if you have this curiosity towards people and you don't get frustrated that easily, then you can be a good lawyer, I think.
Would you accept a proposal to become an ECJ judge?
A judge at the Court of Justice of the European Union is a very, very hard-working person who has a very high responsibility towards the European Union in general. And in my opinion, it is a respected job and definitely somewhere to strive for at one point in your life. But it seems to me, in my own private sphere of thinking, that is not the job for someone with small kids.
Can you share any tips on how to overcome the stress?
There are physical stress eliminators, and there are then mental. And the physical ones that definitely that you have to, there is never enough time to go for gym. I mean, there is never enough. There is always another email, there is always another memo, but you have to, by force, take time for working out. There is no point in letting yourself go because it will only kill you morally. And then later it will be extremely difficult to recover. Then the second thing, what is on the mental side is you don't have to be reading Kafka all the time. You don't have to be reading Dostoevsky. I mean, I love Dostoevsky, it's fantastic. You don't have to be reading law journals all the time. Sometimes you need to just flush your brain with random series from Netflix. Get enough of sleep. Get enough of sleep. And I strive towards 7.5, 8 hours almost every day.
Thank you very much, Carri, for your honest answers. It was a pleasure talking to you. And I'm really looking forward to meet you next year in Minsk during the Eastern European Dispute Resolution Forum.
Thank you very much for these interviews. I hope that your event will be very successful. And let's all get past this COVID thing and get the world going, and let's learn something from it. So, до свидания, спасибо вам большое, and good luck in Minsk.